From daily list under heading for orders to
From daily holiday out of turn may I mention. Serial number 45 is juvenile matter custody.
Section.
Section 376.
Age. Age.
Age is below 16 years.
Serial number.
40.
40.
45.
4 बजे.
Oh,
Serial number 59.
mention
What is it?
59.
What is it?
Section under section 125 CRPC. Distress warrant.
That's the husband.
Yes.
What is your ground?
He is a student. My lord, and 10,000 has been monthly amount has been fixed against him.
Student. Studying where?
Studying in a pharmacy college.
Did you need evidence?
In that evidence, admit card has been exhibited, and admittedly he is arrested.
He does not have any other source of income.
No.
Serial number कौन सा?
59.
59. 4 बजे.
Serial number 34.
क्या?
392 365. I am garage में और चोरी का लुटेड जो गाड़ी था हमारे गैरेज से रिकवर हुआ.
तो क्या है? रिविजन फाइल किए हैं.
Yes.
कन्विक्शन है.
Conviction.
सरेंडर हो गया है.
Surrender. जेल.
बेल पर है.
नहीं बेल पे नहीं.
बेल पिटीशन फाइल किए हैं.
जी बेल पिटीशन फाइल के साथ में लिमिटेशन भी है.
रिकॉर्ड आ गया है.
मेरी कौन
सीरियल नंबर कौन सा है?
34.
4 बजे.
Main reason out of this matter.
Out of this list. From daily list under heading for
विड्रॉल
orders
वाला
to
तो है वो कर लो. 2 matters for withdrawal, right?
From supply.
Your Lordship, the serial number 15, Your Lordship, the RA for this exemption from surrender.
Why are you mentioning now? Mentioning time is over.
No, Your Lordship, from the daily list order.
That mentioning time is over now. Yes.
I'm not mentioning, Your Lordship. My serial number.
Serial number 15 has been called out. No. You wait for your turn.
From supply list under heading for orders withdrawal of cases item 1764 of 2023.
As we wish to withdraw this application, the parties have compromised their issues.
both are separate.
Both are. I will just simply say that you want to withdraw.
Yes.
Learned counsel for the petition seeks permission to withdraw this petition. Permission is accorded. This petition is dismissed and withdrawn. Counsel for the opposite party, private party, has no objection to the prayer for withdrawal. You okay? Next one.
Item 2 criminal event 1606
Same.
Same matters.
Same
The
rules
only
for
thing is
OP
that
number
we-
2. You are there?
No, no. Yes. They for the state. We have filed for
Same
discharge.
order. Same order.
But the matter is.
Same order. Give your appearances, please.
Right.
Communicate. kar.
From daily list item 8 criminal revision 63 of 2023. What is the defect?
कितने मैटर्स हैं डिफेक्टिव आज लिस्ट में?
16.
16.
Yes.
Time till 23rd July is granted to the petitioner to remove the surviving defects preemptory. If the defects are removed within time, pose this case on 8th of August.
Item 9 criminal revision 65 of 2023.
Same order. कोई आइए हो तो बताएंगे.
Yes. Item 10 criminal revision 68 of 2023.
Sorry?
Item serial number 9.
The case order has already been cancelled.
Item 10, Criminal Division 68 of 2023.
Is 10, same order.
Item 11, Criminal Division 74 of 2023.
IA for exemption of servitor.
Rest of the defects have been removed.
Yes.
Item 11,
दिखाई सर.
Criminal 44. 1 month imprisonment, simple imprisonment is there.
Then also you'll have to surrender. There is no IA for exemption.
Yes, sir. The IA is 672 of 2024.
This is not exemption from surrender. ये कौन सा serial number है? कौन सा केस में आपके?
11 laws.
केस नंबर?
45 or 24.
No.
11 में 74.
I apply. I apply.
But then कौन सा?
Item 11, Criminal Division 74 of 2023.
Same order. आपका कौन सा आइटम नंबर है? हाँ? Which is your item number?
उसमें 11 लिख कर दिया था 18 हम चेक कर रहे 18 है I apply.
लिस्ट देखने का भी टाइम नहीं मिलता है.
I apply.
फाइल देखने का तो टाइम नहीं मिलता आप लोग को. आई नो यू आर वेरी बिजी. लिस्ट देखने का भी टाइम नहीं मिलता. सेम ऑर्डर.
Item 12, Criminal Division 1407 of 2023.
सेम ऑर्डर.
Item 13, Criminal Division 1409 of 2023.
सेम ऑर्डर.
This is my
Yes. You have removed all the defects. Sorry? Criminal Division number 1409 of 2023. 2 interlocutory applications are pending for consideration. One is for condonation of delay and other is for exemption from surrender. There are other defects also. Time till 23rd July is granted to the petitioner to remove the other defects. Preemptory, if the defects are removed within time, pose this case under the heading for orders on 5th of August. No, 5th, no, 8th of August.
Item 14, Criminal Division 1412 of 2023.
Same order.
Item 15, Criminal Division 1414 of 2023.
Same order.
Your Lordship, the exemption from the surrender, Your Lordship.
Other defects have been removed.
Yes, Lordship. And petitioners live peacefully conjugal life lead, Your Lordship. The husband and wife. Outside the court, the matter has been settled, Your Lordship. At the time of the conviction, the petitioner is the juvenile, Your Lordship, and 1 year's half, 1.5 साल का सजा हुआ था. Thereafter, it is modified. Then appellate court, Your Lordship, and after the confirmation of modification of the appellate court, the matter has been settled between the parties and lead the conjugal life peacefully. The informant is also appear in this case.
Where have you stated so in your petition?
Lordship,
Where have you stated so in your petition?
and IA, Your Lordship,
Where have
for
you mentioned?
exemption from surrender.
Where have you mentioned
Your Lordship,
that you have settled the dispute and you are living as husband and wife?
yes, Your Lordship.
You have been convicted under section 3 and 4 of Dowry Prohibition Act?
Yes, Your Worship.
Is it a
And for
compoundable
98.
offence? There is a minimum sentence there. There is a minimum sentence, isn't it? Is there or it is not there?
There is minimum sentence, Your Worship. As per the consent of the parties, there may be the compromise option of the parties, Your Worship. दोनों को बुला ले जो एक जॉइंट कंप्रोमाइज बाय वे ऑफ आईआर डलवा देते हैं अगर वैसे।
उनको लेके आइए ना, आप लोग साथ में रह रहे हैं, लेके आइए उनको।
नहीं हाँ, वो तो अपियर भी हुई हैं वकालतनामा डाला
कहाँ है वकालतनामा? तो वेयर इज द काउंसिल?
मैं कॉल काउंसिल
4 बजे आइए, कॉल इन।
Item 16, criminal revision 1415 of 2023.
So there is one defect regarding the surrender certificate. The petitioner is ready to surrender and we will be supplying the surrender certificate within 3 weeks.
I'm just giving you time till 23rd, and the case will be posted on 8th of August. Say what?
Item 17, criminal
It's a
revision
preemptive order, take
1416 of 2023.
इसमें सारे ऑर्डर्स में लिखिएगा, if the defects are not removed within time, office is directed to prepare appropriate office note with regard to dismissal of the case and immediately communicate to the concerned court for further action. यहाँ पे DFD होकर यहाँ हाई कोर्ट में पड़ा नहीं रहना चाहिए कोई।
Item 17, criminal revision 1416 of 2023.
Same order.
Item 18, criminal revision 45 of 2024.
Please check.
IDA petition is there for exemption to surrender.
What is the ground? What is the section?
138. There is simple imprisonment of 1 month. Ground is the
What is the check amount?
check amount, Your Worship, is of rupees 2 lakhs.
Compensation amount?
2,40,000 and fine of rupees 7,000.
You deposit the compensation amount, I'll give you exemption in the High Court.
25% of the petitioner is lady and is suffering from 25%.
No, I'm not inclined to do this. There are conviction from 2 courts. You deposit the amount. I'm not asking you to give any amount. You deposit the amount here. We'll call for the records and decide the case.
Let me take this.
4 बजे 4 o'clock. फाइन डिपॉजिट करने नहीं बोल रहे, कॉम्पनसेशन
I
अमाउंट।
know, 2 lakhs.
Item 19, criminal revision 53 of 2024.
There are 2 stars out of 2. One is regarding court fee matter. उनकी another defect. पैराग्राफ 2 में कहते हैं सेशन कोर्ट में नोट किए कि नहीं, उसके लिए एग्रीमेंट देना चाहिए। पैराग्राफ 2 में लिखे हुए हैं दिस हाई कोर्ट का, सेशन कोर्ट का नहीं।
फाइल करना पड़ेगा ना, डिफेक्ट रिमूव करिए आप।
इसको जो
इग्नोर कैसे हो जाएगा?
पैराग्राफ 2 में
कैसे इग्नोर हो जाएगा? कोई लॉ बताइए।
नॉट बिफोर दिस ऑनरेबल कोर्ट का स्टेटमेंट दिए हुआ है, सेशन कोर्ट का नहीं।
कितना दिन हो गया आपको प्रैक्टिस करते हुए? जरा हमको अपना फिगर बताइए। आप तो ऐसा बोल रहे हैं जैसे कि आप आज ही ज्वाइन किए। इसको इग्नोर कर दीजिए, ये इग्नोर करने लायक डिफेक्ट है।
ठीक है सर, 10 सप्ताह का समय।
प्रेम्प्टी ऑर्डर से मॉडल
कब सर?
23rd तक प्रेम्प्टी 8 तारीख को रहेगा।
Item 20, criminal revision 54 of 2024.
Same order.
Item 21, criminal revisions 59 of 2024.
Same order.
Item 22, criminal revision 60 of 2024.
Same order.
Item 23, criminal revision 66 of 2024.
20 के बाद सीधे 23 कैसे हुआ? 22
22 के बाद।
पता है? बोलना है सेम ऑर्डर राइट. प्रेमट्री ऑर्डर है, डिफेक्ट रिमूव करिए, अपना केस करिए. ठीक है, यहाँ पे पेंडिंग रखने का कोई काम नहीं है डिफेक्टिव केस.
From the supplementary list, under heading for fresh filing, item 4, criminal division 752 of 2023.
Yesterday the council was present.
No, Lordship.
Yesterday also it was not present.
First half it was not appear. Thereafter again at 4 p.m. the same was. Then this case was fixed.
At that point of time also it was not there.
127 against the order of 127.
बड़ी आप प्राइवेट पार्टी हैं स्टेट.
I am for the state.
चलिए मेरिट पे डिसाइड करिए. What is the case?
Initially 125 was filed, wherein the maintenance was given. Maintenance was, Lordship, 5,000 rupees, and that maintenance was filed in the year.
Just a moment. Rejected. Yesterday also nobody had appeared on your behalf. Sorry?
He has gone to Delhi for some treatment.
Who has gone to Delhi
The
for some
arguing
treatment?
counsel.
Who is the arguing counsel?
Mr. Anil Kumar Keshri.
Mr.
Anil Kumar Keshri.
Anil Kumar. कौन है? अनिल कुमार केशरी.
Yes, serial number 4. Anil.
कब आएंगे?
Today morning I was called back.
तो कब के लिए बोले हैं?
Should after a week.
एक हफ्ता में आ जाएंगे? You should have that knowledge. Find it out. कब आएंगे? जब जिन्होंने आपको फोन किया उन्हीं से फोन करके पूछिए कि कौन सा तारीख लगा देंगे. जो आप तारीख बोलेंगे उस तारीख को केस रहेगा और उस दिन आप आएंगे तो भी डिसाइड होगा, नहीं आएंगे तो भी डिसाइड होगा. ठीक है, फोन करके पता करके 4 बजे आइए. एब्सेंट मत रहिएगा. व्हाट्स योर नेम?
मोहम्मद इमरान.
आप आइए 4 बजे. हम डेट देंगे. मेडिकल ग्राउंड पे डेट हमको देना ही है, लेकिन आपके कंसेंट से डेट.
Item 5, criminal division 859 of 2023.
Lordship, this against the order of maintenance, Your Lordships. And admittedly, petitioner is the husband of the OP number 2, Your Lordship.
So, what is it from?
Your Lordship, several attempts he has taken to bring her back in the year of 2022, 2021, and he has also filed, Your Lordships, in the year 2022 restitution of conjugal rights. And thereafter, in the month of January, Your Lordships, he has filed 498
When did you
case.
file restitution of conjugal
In the year 2022, Your Lordship. And she has filed, lodged a case against him in the year 2023, Your Lordship.
So,
And Your Lordship, इकरारनामा भी हुआ था, Your Lordship. पहले एक dispute हुआ था, उस पे इकरारनामा हुआ था.
what is the date of that इकरारनामा?
इकरारनामा के Your Lordship, उसमें annexure लगाए हैं, annexure 1 है, Your Lordship.
नहीं, इम्प्यून ऑर्डर से बताइए. एनेक्शर 1 से नहीं चलेगा. इम्प्यून ऑर्डर से बताइए कि आपने
ये सर उसके एविडेंस भी आए इकरारनामे के बारे में उनके, क्योंकि फैमिली भी इन्वॉल्व
कब है, डेट कब?
23/1/2021, Your Lordship.
23
23 July 2021.
7/2020. What was the agreement?
Your Lordships, वो चली गई थी अपने मायके. उसके बाद Your Lordships, वो वहाँ से कहीं चली गई थी बिना बताए. Your Lordship, उसको लेकर डिस्प्यूट हुआ था, तो उसके फैमिलीज इन्वॉल्व हुए थे. फिर इकरारनामा हुआ था कि वो बात मानेगी और अच्छे से रहेगी. Your Lordships, ये इकरारनामा था. Your Lordship, वो फिर रहने भी लगी थी. फिर वो एक बार पूजा के नाम से Your Lordship गई, उसके दो वापस नहीं आई. उसके लिए फिर काफ़ी सेवरल अटेम्प्ट्स भी लिए उन्होंने और रेस्टिट्यूशन ऑफ कंजुगल राइट्स का केस भी फाइल किया. इवन उनका मदर का भी कहना है कि 1 साल पहले वो आए थे हमारे घर पे. उनका एविडेंस में आया Lordship.
तो 498A का केस चलेगा तो वो कैसे
तो
जाएगा?
लॉर्डशिप 498 का केस वो बाद में किया, वो कहती
बाद
है
में
कि
की है तो
हमको
क्या
निकाल
करें?
दिए, लेकिन लॉर्डशिप निकाले है ही नहीं, हमको रखना है मेरा ये लॉर्डशिप।
498A का केस में there are allegations, no?
Yes, lordship.
Then how will she live with you?
But lordship, my bona fide lordship may be seen lordship.
No, we will not.
क्योंकि
See, in a case where the lady has already instituted a case under section 498A, then she has a reasonable ground not to live with you. Whatever be the reason, and the ground is attributable to you only. So we can't ask her to live with you. आपका restitution भी तो आप pending रखे हुए हैं, allow
नहीं
नहीं हुआ है.
लordship, allow नहीं, reject हो गया मेरा restitution,
Reject हो गया
reject
ना?
हो गया।
तो फिर-
जिसके लordship से हम यहाँ पे आए हैं,
That's right.
first appeal has also been
वाइफ
filed.
है ना आपकी?
Yes, sir.
पहले पेमेंट पैसा देकर उसको ये तो कॉन्फिडेंस में लीजिए कि आप उनको मेंटेन करेंगे.
Yes, sir. In the meantime, notices may be
meantime,
issued,
no,
your
no,
lordship.
no.
Notices may be issued because
नो,
first
अगर
appeal
मान
is also.
लीजिए जस्ट अ मोमेंट, अगर आपका सुलह हो जाता है,
Yes,
यू
sir.
फाइल योर पिटिशन फॉर मॉडिफिकेशन ऑफ द ऑर्डर ऑफ
Your lordship, in this case only an attempt may be taken, your lordship. If only one attempt, notices may be issued.
कोई
Notice may be issued, your lordship.
कुछ नहीं
एक बार लॉर्डशिप नोटिस इशू कर देते, क्योंकि लॉर्डशिप हम फाइल की इकरारनामा भी एंड
इससे कुछ नहीं ना, रेस्टिट्यूशन आपका रिजेक्ट हो गया है ना,
Yes,
बात खत्म हो गई, राइट?
But your lordship, one attempt may be given, your lordship, because I want to live with her, your lordships.
Criminal revision number 859 of 2023. For the learned counsel for the petitioner, this revision has been filed against order dated 31/5/2023, passed by learned Principal Judge Family Court Pakpur in original maintenance case number 19 of 23, whereby the learned Principal Judge has been
One thing, your lordship, on the quantum of maintenance, your lordship, the grocery shop owner is not, he's not the grocery shop owner, he's one of the member of the family, and the grocery shop belongs to his father, your lordships. So on the quantum of maintenance may be seen, your lordships.
So आपका तो ये 125 में you have 8,000 rupees.
So your lordship may be reduced to at least 6,000, your lordship, not much. She is single and there is no child, your lordships. So 6,000 may be done, your lordship.
You are earning.
Yes,
It's your
yes,
family
I'm earning,
business.
being-
You are earning.
Being a family member, yes,
And
sir.
even if you are not earning, then also 8,000 is to be awarded, isn't it? As per the judgment of Neha versus Sisi.
Yes, your lordship, but
आप
1/3.
आप crippled हैं, disabled हैं, differently abled हैं, नहीं है ना? Able-bodied person, you are bound to give maintenance. That is your obligation. You don't interfere.
She is also studying and your lordship, she is doing MA, your lordship. She has completed her MA.
इसीलिए उनकी पढ़ाई में सपोर्ट करें.
So your lordship, 1,000 at least, your lordship, some reduction may be done, your lordship. Because he is not the owner of the shop, your lordship. That's why I was praying, your lordship. He is not the only owner, your lordship. He is one of the partner, being a family member, your lordship.
Whereby a maintenance amount of rupees 8,000 per month has been fixed, payable from the date of application, that is from 4/2/2023, with litigation cost of rupees 10,000, and arrears has been directed to be paid within 12 equal monthly installments. The learned counsel for the petitioner has submitted that the marriage between the parties is not in dispute, and the petitioner has been throughout willing to keep the opposite party number 2. The date of marriage is 6/3/2018, and on 22/10/2020, the respondent had gone to her parents' house without informing the petitioner, and ultimately, by virtue of agreement dated 23/7/2021, the petitioner came back, the opposite party number 2 came back to the matrimonial house. The learned counsel has submitted that a petition for restitution of conjugal rights. Thereafter, the opposite party number 2 again left the petitioner. The learned counsel has also submitted that a petition for restitution of conjugal rights was also filed, but the same has been dismissed. But the petitioner is ready to keep the opposite party number 2. He has also submitted that the petitioner is running a grocery shop and SBI Grahak Seva Kendra which actually belongs to his family, and it is a family business. And therefore, the quantum of maintenance to the extent of rupees 8,000 calls for interference. After hearing the counsel for the petitioner, and upon going through the impugned judgment, this court finds that the marriage between the parties is not in dispute. And upon notice, the petitioner had appeared before the learned court. Upon appearance, the learned court framed the following issues para formam. The witnesses, documentary and oral, has been mentioned in paragraph 5 as follows. The opposite party number 2 had deposed and she was also fully cross-examined. The mother of the applicant was examined as PW2. She was also cross-examined. The petitioner was examined as DW1. And had deposed that the opposite party number 2 gives tuition and he does not have the livelihood expenses and educational expenses of the opposite party number 2, and that the opposite party number 2 has lodged a case against him and his family member in connection with demand of dowry, and they have been released on bail, and no child was born out of wedlock. He has also deposed that the name of the Pradhan of the village is Shiv Kumar Yadav, and in his house a paper of agreement was prepared. In his village about 7 to 8 grocery shops are present. Another witness was examined from his side, DW2. He was also cross-examined. The learned court considered the issues framed and ultimately, after considering the evidences on record, found that the applicant had filed a case against her husband and family members with regard to demand of dowry, torture and assault, which was registered as PS case number 8 of 2023, dated 10/1/2023, under section 498A, 341, 323, 504/34 of IPC and 3 and 4 of Dowry Prohibition Act. And that the applicant was a student of MA. It has also been recorded by the learned court that the father of the opposite party was Gram Pradhan, and the opposite party was economically and politically sound and was running a grocery shop and one SBI Grahak Seva Kendra and had landed property. This court further finds that the learned court considered the various judicial pronouncements and recorded that the question of denial of maintenance would arise only if the This court finds that the plea of the petitioner being unemployed was rejected by the learned court by considering the materials on record, and the learned court has recorded that there was consistent evidence of the witnesses on the point that the petitioner was running a grocery shop in his house and one SBI Grahak Seva Kendra and has landed property and has tentatively taken the monthly income as rupees 30,000. However, while considering the quantum of maintenance, has fixed a maintenance amount of rupees 8,000 only. After having gone through the impugned order, this court finds that that maintenance amount of only rupees 8,000 has been fixed.
No documentary evidences has been produced regarding that.
Need not be. Which is a meager amount, and the impugned order has also recorded that the petitioner has no other financial liabilities. No ground for interference in judicial jurisdiction has been made out by the petitioner, hence rejected. The learned counsel has also submitted during course of hearing that the petition for restitution of conjugal rights has been rejected by the court concerned.
Your first appeal has been filed.
And the first appeal has been filed, which is pending before this court.
Item 6, Criminal Revision 421 of 2024.
What is the challenge herein is an order passed by the Juvenile Justice Board, Dhanbad, which was put in appeal by us, and the appeal was also dismissed by the Special Court Children, Dhanbad. Now the issue herein is, that in section 15, suppose somebody is declared juvenile, there is a offence which is serious in nature.
What
Now
is the
whether-
date of offence?
Yes, please. We give the list of dates, please. But the date of occurrence is
Give me the list.
date of occurrence is 2/7/2018. The FIR was lodged on 5/7/2018. 7/7/2018, the petitioner was arrested. 9/10/2020, the petitioner was released from jail. 13/5/2022, application filed for declaring juvenile. 4/7/2022, petitioner declared juvenile. Around 17 months, 17 years, 17 years, 7 months was the date of the juvenile.
On the date of occurrence.
On the date of occurrence.
Okay.
Now,
Almost 18 years. Just a
almost.
few months.
Few months back.
That's right.
Few months back.
Then she was examined
Then it's
under section 15.
yes. Then the section 15 order was passed on 11/9/2023.
That's right.
Now, the preliminary assessment, there was some report, and on the basis of report, medical report, the court found that she was fit to understand as per the assessment done by the medical
That's
board, and she was sent to the court, or the children court, for trial.
That's right.
Now
What
when
is
we
the stage of that trial?
charge, framing of charge,
Then what happened?
numbers. Now we challenged that the assessment which has been done.
Where is that application?
Yes, minutes. The application.
आपका
Yes,
जो
I'll just
जो basis है आपके केस का वही आप नहीं लगाते हैं.
ठीक है. I'll just cut short the matter. Now we can just decide the issue in a very simple. 19.1. 19.1 is a section wherein even the children court is supposed to decide if there is an application or even otherwise. 19.1, the court has to decide whether the juvenile is to be tried by the children court or the juvenile has to send back to the judge. That section has to be complied. which
Just
is
a moment.
Nowadays,
After
I'll
the
give the-
assessment,
Yes,
after the
even-
assessment under section 15,
15. Yes, yes, yes.
once the juvenile is held to be fit to be tried as an adult,
Adult.
then after that the record is to be transmitted to the children court for
Children
trial.
court. Yes, yes.
So there is no question of any further decision.
That is the issue which has been decided by the Supreme Court. That is not being done, which should be done. Which should be done.
That must have been done in this case. Where do you say that this has not been done?
This
She
the
has
order-
been, the
the-
assessment has been made. She has been, there is an order passed by the court that she has to be tried as an adult. There is no such order.
Yes, there is an order under 15
Under
by
section
the judge
15,
board.
naturally,
The
then the
matter goes to
matter,
the court.
the matter goes to the
Court.
children's court.
Then the children's court has to again exercise power under section 19(1). That is the view of
So
the
there will be
Honorable
two
Appellate
orders.
Court. Yes.
Where is that judgment of the Supreme Court?
Yes.
That there should be two orders.
Yes, this-
So that is not the matter of challenge before this court.
See, matter of challenge. The
Let us see
appeal-
the impugned order. We
Yes.
are in revisional jurisdiction.
Yes, we will certainly,
Yes.
we'll certainly test that particular order and the judgment which was cited and the judgment which was appreciated, whether that judgment was wrongly appreciated by the appellate court. That
No,
also.
let us see the nature of order.
Yes, certainly. So let us see the
We
impugned.
will only see the impugned order. You are challenging
Sure.
your assessment.
Sure.
Yes.
The judgment is
11/9/23. You
Yes.
filed it before the Juvenile
Second-
Justice Board.
Juvenile Justice Board. There were the ones he was this petitioner was sent to the court. She had no say. She was not aware of the record. She was not provided what was the report of the medical board. Because what she has to say, what we have.
Which court and when that order was passed that she has to be tried as an adult? What is
Yes.
the date of that order?
The date of that order is Manoj 11/9/2020.
11/9/23.
9/2020. So yes. Now this order, this order is.
We just see this order. This order has been filed.
The judgment would be
This
the
is
judgment.
there. No, it is there in the. You have filed it. 11/9/23 order.
11/9/23
Yes.
order.
That order is not in my file also.
But that order is not there. The issue.
This 11/9/23 was the order which was subject matter of appeal.
No. That was not the subject matter. What happened thereafter was we made an application that look here. Where is the assessment? Where is the medical board report? I
You
wish
see,
to
being
go through the.
dissatisfied by the order dated 11/9/23. That is the order of impugned in the appeal. You say that you are not aggrieved by that order.
No, we are aggrieved by that. I'm saying what was the stage, at which stage. 11/9/23 order is not before my lords, which has not been filed by us.
It has been filed by you. उस पर डिफेक्ट था, आपने वो फाइल किया है और आपके पास नहीं है.
Right. I have that order. I'm sorry. The defect issue. I did not check in the defect issue. That order is there. I'll read that order. That order itself is make it very clear that as a post office, the Juvenile Justice Board simply looking into the preliminary assessment done, the report of the medical board transfers the case to the children's court.
और क्या करेगा वो? You see, you have been sent for psychological assessment.
इसका तरीका है
You have been sent for psychological assessment.
That was not done
Right?
properly.
That was done.
That was not.
You were
That is,
sent to Rinpass. You appeared before Rinpass.
yes,
Yes.
but they did not ask a single question to her. She simply appeared.
So that is why your objection to that report is absolutely relevant for this case, which you have not filed.
They have not given us. That is my case.
Application. You filed an application objecting to that.
I filed an application
Where is
of
your
providing.
application?
My application of providing, and that was rejected subsequently. I'll just give the stages, Manoj, how this 11/9/2023 was passed. I was not made. I did not participate exactly in that proceedings, so that before passing of that order, by reading the final judgment, everything would be clear. I have a very simple case. I'll just cut short the matter. I have a very simple case. If the issue has been raised by me regarding the fact that I should not
I just can't get it. 11/9/23 opening sentence. Today this case has been put up for orders on petition dated 22/11/2022. Copy has already been served to learned APP.
Yes.
And I am looking for this application. Where is that? That is the genesis of the order dated 11/9/2023. Where is that application?
Let us, for a moment, let us.
जो एप्लीकेशन आपने फाइल किया उसको बिना देखे तो हम कोई ऑर्डर नहीं कर
नहीं, ठीक,
आप कितना ही देर बहस कर
ठीक, नहीं, हम एक थोड़ा
तो
सा,
आप वो फाइल करिए
थोड़ा सा एक चीज जस्ट कट शॉर्ट.
आपका
आप
मेन टॉक
एक बात सुनिए ना, एक बात सुन लीजिए. जस्ट टू कट शॉर्ट द मैटर, your lordship, because I know, your lordship, section 19, still the matter can be remanded back.
नहीं, I will not remand back the matter unless I see what petition did you file. You file that petition, आपके पास है तो अभी दिखाइए क्या petition आपने फाइल किया था. एक आप फाइल कर दीजिए.
No petition. Let it be next. But what the issue was, I'll just try to explain, what is going on is that the section 19 is not being applied by the Children's Court. Children's Court had simply taken my application and decide himself.
You have filed a petition before the Juvenile Justice Court.
Yes, that
You
was
did not file your application before the Children's Court.
that was the step which they have taken. I cannot just say why that step was taken, and rightly taken. Why? Because they were asking for the copy of the medical board report so that they could challenge that medical board report. The medical board report was not given to them. They simply said that you can very well come and see what is the report, but you will be not provided a copy. So that was the challenge. That was rejected. And they said that now I become functus officio because I have already transmitted the entire files to the Children's Court.
That's right.
Okay, you transmit the entire files to the Children's Court. The Children's Court should have applied its mind under section 19. That
No
is the
cause
case.
of action from the Children's Court is arising in this revision application.
The judgment?
No, that is an appellate judgment. Children's Court में Juvenile Justice Board के order का appeal भी वहीं जाता है.
गया है. अब let us read what is the judgment he relies upon. एकदम से उसे clear हो जाएगा. उनके खुद के judgment का last part, if I just take 30 seconds of my notes. Let us read the last part. Last part of the judgment which I have assailed before.
The appellate jurisdiction, this is what it is.
What para 13 says. He could have taken cue from this particular judgment. This is what the Supreme Court judgment is about. That if at all this has come before you, you can very well exercise your power under section 19. And that is the judgment, the recent judgment given by me to my lords. That all said and done, the Children's Court can very well, and Children's Court must exercise its power under section 19. If they have exercised, the Children's Court has exercised power under section 19(1). I have no case. If it has not exercised, then the matter has to be exercised. This is the simple case. Without going into the merits of the case. This is what the Supreme Court time again is trying to explain to the Children's Court. That very well, I have the right. I have that right, and in fact, even if I don't mention, the court has to take this exercise of section 19(1). of deciding whether yes, it has to conduct the trial keeping in view that the juvenile is to be tried, is given a regular trial. The judgment Varun Chandra Thakur also is very clear.
You see, by this time, the record were sent to the children court,
Yes,
and then what happened?
the children court did not exercise its power on section 19(1). But I would say that they were not even the people. So in any case, the matter can be decided by the children's court. The children's courts can once again look into the matter whether she is fit to be tried as per section 19(1). She can be given a chance. That is the only case. That is the only case. Without going into the merits of the case. If not taken that exercise, if they have already taken up that exercise, then I have no case. If not taken that exercise, then the court has to take up that exercise under 19(1).
The learned counsel for the parties are present. Call for the records from the court of children court का record बताइए, case number बताइए. Court of Special Judge Children Court Dhanbad.
Yes, please.
In connection with वहाँ केस नंबर पड़ा होगा ना, बताइए
GR case number 2 वहाँ पे I'll just
which is arising out of record transmitted by Juvenile Justice Board Dhanbad,
arising out of
Juvenile GR-2705/2022 Barwadda PS case number 131 of 2018. Office is also directed to call for the records from the Juvenile Justice Board, from the available records which might be there with the Juvenile Justice Board in connection with the aforesaid case. Counsel for the petitioner has submitted that once there is an assessment by medical examination that the child is to be tried as an adult, a specific order is required to be passed by the Children's Court in terms of section 19.
Well, yes, that's right.
And in absence of such an order, the Children's Court does not have the requisite, cannot proceed further to try the child as an adult. They have submitted that this aspect of the matter is required to be taken care of in these proceedings. Otherwise, there will be miscarriage of justice so far as the child is concerned.
That's
Counsel for the state is also directed to seek instructions and file a contract in this case. Let this order be communicated to us.
small date.
Yes, relied upon the judgment passed by the Honorable Supreme Court reported in 2023 Live Law SC 857. पूरा order sheet भी आना चाहिए along with the order sheet of the case.
A date.
The order sheet and the medical assessment of the child. Medical/psychological assessment of the child. post this case on first of August under the heading for final disposal.
Under heading for admission, item 7, WPL 5835 of 2010.
My lord, I am very sorry, I beg to apologize, my lord. Sometime maybe given in this case, party has, my lord, engaged the senior, my lord.
I will not grant you any.
I never took a time, मतलब कभी हमने नहीं लिया है
बहुत
लॉर्डशिप,
अच्छी बात है।
और वो मतलब सीनियर इसमें रखना चाहते हैं।
कुछ इसमें सीनियर का काम नहीं है।
Every occasion may not by hook and crook is trying to take the acknowledgement.
आप दिखा दीजिए कि एक भी ऑर्डर हमने
आप
लिया
हमको
है।
एक बात बताइए, सुनिए ना,
जो करना
ऐसे नहीं हो सकता ना।
नहीं लॉर्डशिप, ये जो हम पर गलत आरोप लगा रहे हो, जो
आप आरोप लगाना बंद करिए, केस पे फोकस करिए, क्योंकि उन्होंने जो आपके ऊपर आरोप लगाया वो मुझे सुनाई भी नहीं देता। आप लोग का आपसी बात हमको सुनाई नहीं देता है। कान में फिल्टर लगा हुआ है, नहीं सुनाई देता। आप पेज नंबर, आप सुनिए ना, आप मेरी बात तो सुनिए
जी।
सीनियर के बिना केस आपके फेवर में हो जाए तो आपको तकलीफ है?
नहीं, उसमें अपने मान लें कि अगर होगा तो फिर
कुछ नहीं, कुछ। पेज नंबर 14 में आइए आप अपनी पिटीशन। पेज नंबर 14।
Yes,
ठीक है, just read 5 lines from the top. The appellant company requested. पढ़िए।
from fifth line from the top.
Yes.
The
One.
appellant company
Yes.
requested the chairman's CBT employee provision New Delhi for waiver of damages within under section 14B of the by order dated this such further amended by order dated 24/3/15 Annexure D and the same is pending.
Is pending. ठीक है?
Date.
है ना? Pending था, but still he went ahead to pass an order and modified the damages. As per the act, the application was to be filed before the chairman. वो जो pending है उसको disposal का order कर देते हैं।
If it is still disposal, then it may be.
Still कैसे? आपको तो order हो गया, अब क्या pending होगा वहाँ पे? अब तो कुछ भी pending नहीं होगा। कौन है आपके सीनियर? किसको बहस करना? आपके सीनियर कौन है? किनको बहस करना है?
मैं पार्टी बोला है उसके बाद सीनियर रख के
ऐसे नहीं होगा, right? Therefore, under such circumstances, there was no occasion for him to himself modify it. है ना? समझ में आ रहा है आपको बात?
जी मैम।
आपने एप्लीकेशन प्रॉपर फोरम में फाइल किया हुआ है, वो पेंडिंग था।
जी लॉर्डशिप।
तो ये ऑर्डर से कैसे वो मॉडिफाई कर देते और उस एप्लीकेशन को इनफैक्ट्रेस बना देते? इसीलिए
दो ऑनरेबल कोर्ट ने दो उनके एसएससी बुलाया गया कि भाई आप बताइए कि किस तरह से बैठे बैठे जो है आप कंप्यूटर में बैठे बैठे कर वो आए हैं, कोर्ट को समझाए हैं, कोर्ट समझ उसके बाद जो है ये 29 लाख से रुपये, और ये 2005 में यूनिवर्सिटी के इंडस्ट्रीज हो गया था लॉर्डशिप बाय द बिहार गवर्नमेंट एज वेल झारखंड गवर्नमेंट, और सारा का सारा चीज़ हमने चिट्ठी में लिखा है, अगर कुछ बाकी है तो बोलिए। उसका 2013 में वारंट इशू कर देते हैं, देन वी फाइल एप्लीकेशन बिफोर द WPC एनेक्सर लगाया हुआ, तो उसमें बोले कि जाए कि सारा चीज़ आप कैलकुलेशन करके दीजिए, जो भी बाकी है हमने सारा करके उनको दे दिया। उसके बाद ये बोल रहे हैं कि नहीं अभी ट्रिब्यूनल तो पावर नहीं है।
ट्रिब्यूनल को तो पावर नहीं है, ट्रिब्यूनल को तो एक्चुअल में पावर नहीं है। जब पेंडिंग था मैटर कहीं पर तो ट्रिब्यूनल को कैसे पावर हो जाएगा उसको डिसाइड करने का?
उसको तो डिसाइड किए नहीं,
कैसे वो कर देगा? एंड्स ऑफ जस्टिस में ट्रिब्यूनल को कहाँ से पावर?
तो चूंकि डैमेजेस के लिए था लॉर्डशिप, इसमें ये लिखे हैं कि ये सेंट्रल बोर्ड ऑफ ट्रस्टी को है, तो ये अपेलेट ट्रिब्यूनल, अपेलेट भी तो इन्हीं का ट्रिब्यूनल है। जब ये गए थे और अगर मान ली हम गए थे तो ये
आपके उसका क्या हुआ जो सिक यूनिट वाला जो था
वो सारा चीज़ खत्म हो गया, वाइंड अप हो गया, सब चीज़ बेच बाच के सब समाप्त हो गया। जितना जिसको पैसा देना था लॉर्डशिप हमने दे दिया, बैंक को दिया, DRT सारा चीज़ एवरीथिंग कुछ है नहीं, वो सारा सब हो गया और 2005 में ही हुआ लॉर्डशिप।
तो वेवर का आपका एप्लीकेशन जो भी था, आप वहाँ पे उसको डिसाइड करा लीजिए। आपको वेवर का एप्लीकेशन था ना आपका?
जी, तो वेवर का था तो वेव कर लिया और 25% जमा करना था, हमने जमा कर दिया।
जमा कर दिया। तो ये वाला जो है ना, ये जो वेवर का जो एप्लीकेशन है, आप इसको डिसाइड करवा लीजिए। हम इस ऑर्डर को सेटिसाइड कर देंगे, आपका वेवर का एप्लीकेशन रिवाइव हो जाएगा, आप इसको डिसाइड करा लीजिए।
तो ये लॉर्डशिप
सिंपल सा बात है।
लेकिन तो ट्रिब्यूनल भी तो राइटली किया है
नहीं
एससीसी।
नहीं, ट्रिब्यूनल को जुरिस्डिक्शन नहीं, और खास तौर पे जब पेंडिंग है एप्लीकेशन।
My lord, kindly.
When the application was pending, how the tribunal could have decided it and exercised the power of the board of trustees?
है मैडम, लॉर्डशिप हम ये बता रहे, एक है 2024 एससीसी ऑनलाइन 1048। मैं लास्ट में कर ले पढ़ लेते हैं। इन व्यू ऑफ द एबव सेट,
इधर दिखाइए प्रिंट,
ये लास्ट
ये नया जो जजमेंट आया है वो तो इसमें कंसिडर नहीं हुआ ना। See, the central board, this appellate tribunal, as per this judgment, is the appellate authority also for the board. right? As per this order. Then unless the board exercises the power, how would the tribunal exercise that power? आपके केस को हम खारिज थोड़ी कर बोल रहे हैं कि बोर्ड के पास मैटर पेंडिंग था, द बोर्ड ought to have exercised the power and the appellate tribunal ought to have asked the board to exercise the power, and if the board had passed any order against you, you could have filed an appeal against that before the tribunal. ट्रायल कोर्ट को बिना डिसाइड किए हुए हाई कोर्ट कोई पावर एक्सरसाइज करता है क्या? नॉर्मल सर्कमस्टांसेस में नहीं करता. सिंपल. The board will still exercise the power. What's the big deal about it? The matter was pending and that application will be decided. इतना ही.
My lord, so far my knowledge is legal knowledge is concerned, my lord. अपील हम गए, हमको तो अलाउ हुआ लॉर्डशिप. अगर हुआ होता तो इनको जाना चाहिए था, और चूंकि ट्रिब्यूनल भी तो इन्हीं का है लॉर्डशिप, तो
इनका नहीं होता.
मतलब
ट्रिब्यूनल किसी का पर्सनल नहीं होता.
लॉर्डशिप डिपार्टमेंट का है. तो हम वहाँ पर गए. और दूसरी चीज़ है कि 2005 में मेरा सिक इंडस्ट्रीज हो गया, सारा फैक्ट्री बंद हो गई, सब चीज़.
सिक का सारा प्रोसीडिंग अबेट हो गया, जो वाइंड अप हो गया सो हो गया, नहीं तो सारा का सारा मैटर एनसीएलटी में चला.
अब तो कुछ
अब
है
तो वो रिपील हो गया ना एक्ट
जी.
सिक यूनिट वाला जो एक्ट है, सिक का 85 का एक्ट हैज बीन रिपील्ड एंड नाउ वी हैव एनसीएलटी, राइट? Insolvency code, right? Insolvency and bankruptcy code. So therefore, whatever was your petition which was filed before the tribunal ought to have waited for the result of that. That is it. इसके अलावा तो कुछ बोलने का स्कोप ही नहीं है.
मैडम, हम भी रिक्वेस्ट है विद द फोल्डिंग हैंड मैडम, हमको एक डेट दीजिए सो दैट इसमें सीनियर वो कर लेंगे. अगर डिसमिस होता है तो हमारे ऊपर नहीं जाएगा लॉर्डशिप. 2010 से चला रहा है.
आपके क्लाइंट ने अभी सीनियर का नाम तक नहीं आपको बताया है किसको करना है.
वो कर लेंगे. 2 दिन का समय दीजिए. हम कभी समय नहीं मांगे लॉर्डशिप विद फोल्डिंग हैंड मैडम. 2010 से चला आ रहा है 25 साल, तो इसमें कुछ नहीं हुआ तो 2-4 रोज कुछ नहीं हुआ लॉर्डशिप हमको दे देते. अगर डिसमिस होता
तो उस दिन फिर आप फिर ये मत बताइएगा फलना सीनियर अपीयर करेंगे तो इसलिए टाइम दे दीजिए.
नहीं.
और आपके सीनियर भी खड़ा होकर नहीं बोलेंगे कि आज ही हमको एंगेज किया इसलिए टाइम दे दीजिए. ये सब कहानी नहीं सुनेंगे. ठीक है, इनका सबमिशन रिकॉर्ड कर देते हैं, आपके आर्गुमेंट के लिए डेट दे देते हैं. सीनियर को लेके आइएगा, उनको आर्गुमेंट दिखा भी दीजिएगा, नहीं तो यूट्यूब में दिखा दीजिए.
नहीं करेंगे लॉर्डशिप.
नहीं दिखा दीजिएगा. ही हैज गॉट राइट टू सी कि कोर्ट में क्या हो रहा है.
नहीं वो इतना
नहीं विश्वास का बात नहीं है. यू सी इट इज मेंट फॉर द लिटिगेंट टू सी कि कोर्ट में क्या हो रहा है उनका केस में. आपके लिटिगेंट भी देख सकते हैं कि हमारा क्या व्यू है, हम क्या सोच रहे हैं. ऑर्डर में तो हम लिखाएंगे ही, इसमें कुछ गलत चीज नहीं है.
The client is
कुछ ऐसा नहीं.
he also known my lord's view.
नहीं, ऑर्डर में लिखाते हैं. ठीक है,
मुझे तो इसको
एडजर्न करेंगे आपके लिए. इनका सबमिशन तो लिखा दें, उसमें भी आपको परेशानी है. ये जो आपका जो ऑर्डर है इसमें लिखा हुआ है that appellant company had moved the board and the petition was pending.
Yes, that is on the impugned order.
It is in the impugned order. Then under such circumstances, you should not have any grievance if the matter is decided by the board. You cannot have any grievance.
Board is the competent authority.
That's right.
Yes.
Right. And therefore, this order should go.
I have full agreement with the view of the court.
That's this WPC number 5835 of 2010. The learned counsel for the petitioner, while challenging the impugned order dated 7/3/2008, passed by the presiding officer of Employees Provident Fund, Appellate Tribunal, New Delhi, has submitted that the impugned order that as per the provisions of section 14 capital B proviso, the central Board of Trustees, the Chairman Central Board of Trustees Employees Provident Fund has the necessary jurisdiction to reduce the damages in case of sick industrial company. He submits that the impugned order reflects that a petition was filed by the respondent, by the private respondent, and the same was pending. He submits that this having been brought to the knowledge of the appellate tribunal, the appellate tribunal ought to have directed the Central Board of Trustee to dispose of the matter regarding waiver of damages instead of itself reducing the damages to 50%, to 75%. The learned counsel has submitted that he has no objection if the pending petition is directed to be disposed of by the Central Board of Trustee. He submits that apart from the aforesaid facts, otherwise also the impugned order calls for interference. The learned counsel for the respondent has relied upon a judgment passed by Honorable Madras High Court reported in 2024 SCC Online Madras 1048 to submit that the appellate tribunal has the jurisdiction to waive or reduce the damages under section 14 which has been levied under section 14 capital B of the Act of 1952. However, from the perusal of the said judgment, this court finds that it has been held by that judgment that the appellate tribunal is also the appellate tribunal for the orders passed by the Central Board of Trustee. In the present case, the matter was pending before the Central Board of Trustee, and there was no occasion to file and no appeal was filed against any order passed by Central Board of Trustee. At this, the counsel for the respondent prays that the matter be posted on Friday, on Monday, under the heading for final disposal. It is made clear that no further adjournment will be granted. To be taken up at first case at 2:15.
2:15.
2:15 बजे. Final disposal 2:15 ही बजे. The counsel for the respondent shall also inform this court as to whether the respondent company was ultimately wound up or not.
हो गया नोट सारी चीज़.
आपका वर्बल चीज से नहीं चलेगा, ऑर्डर चाहिए. बाइंडिंग आपका ऑर्डर चाहिए, लेके आइएगा.
हमें ये में भी लिखे हुए हैं, काउंटर में भी लिखे हुए हैं.
अच्छा, वाइंड अप हो गया, काउंटर में लिखे हुए हैं.
उनके परमिशन से हम जाकर ये परमिशन दिए हैं, परमिशन लिए हैं, तब जो है.
अच्छा, लास्ट लाइन छोड़.
बेचना शुरू किए हैं.
Item 8, WPL 6155 of 2020.
Lord, the case has been assigned today itself, and I will be filing the Vakalatnama.
रेस्टोरेशन किसने फाइल किया?
That was filed by Madam Binani Verma. After that, the record was transferred to me, and finally it was restored by me. I was appealing.
Yes, at the time of restoration, you were only appealing.
Lord. On 12th of March 2024, the same was restored.
देख लिया ऑर्डर, क्या बोलना है?
Madam, I am sorry, Your Lordship, that order is in context with the mensuria cannot be a ground for calculating the damages, because I will show that judgment. I have read that. हम उसी पे थोड़ा बता देते हैं. I will show one latest judgment also. ये देखा जाए, इसका पैरा 8 देखा जाए सर. Para 8 देखा जाए, this was the specific plea that was taken by the appellant before the tribunal. Para 8 of that judgment, the learned counsel for the appellant submits that the justification tendered by the appellant for which the contribution of EPF could not have been deposited has not been looked into by the authority, and the element of mensuria or actus reus is one of the essential elements which has not been taken note of by the authority while imposing damages under 14B of the 1952 Act. In support of his submissions, the counsel for the appellant has placed reliance on the judgment of ECI Corporation versus HMT and McLeod Russell versus Regional Provident. Now this McLeod Russell and ये जो है इसका consider हुआ है, देखा जाए जो ये
क्या बोलना चाहते हैं? This judgment has got no relevance.
नहीं, it has relevance. हम क्या बोलना चाहते हैं कि in this case the specific plea of mensuria was raised, which the Honorable Supreme Court held in terms of subsequent judgment कि para 15 and 16 से देख लिया जाए, it will clarify the position, because in Dilip and Saraff केस में ये फॉलो हुआ.
आप सीधा बोलिए, हम पढ़ के आए पूरा.
अच्छा, हम ये बोल रहे हैं ना कि पैराग्राफ 15 and 16 में है, there are two judgments of 2008 and 2007 that was overruled in the subsequent judgment passed by Supreme Court in Dharmender textile proceedings, and the Supreme Court has followed that order, that is the law of the land, that mensuria is not an element for imposing damages. Therefore it has been held that the plea that mensuria was an essential element and that was not looked into by the authority, that was turned down by the Supreme Court. This judgment is only to that extent. Now if your lordship permits on merits, I will clarify this judgment. ये judgment जो एक केस में consider हुआ है latest, वो भी हम दिखा देते हैं, that will clarify the position. ये है ये पैराग्राफ 5 देखा जाए, दिस जजमेंट हैज बीन कंसीडर्ड. इसका पैरा 5 it is no doubt true that in horticulture experiment station so and so supra, while dealing with the question of damages under EPF Act, the Supreme Court followed the view in SEBI versus Ram Mutual Fund so and so that a breach of civil obligation which attracts penalty in the nature of fine under the provisions of the Act and the regulation would immediately attract the levy of penalty irrespective of the fact whether contravention must be made by the defaulter with guilty intention or not. We also further held that unless the language of the statute indicates the need to establish the presence of mensuria, it is wholly unnecessary to ascertain whether such a violation was intentional or not. The above view in respect of penalty provision in SEBI Act in Sri Ram Mutual Fund was followed by a 3-bench of the Supreme Court of India in Union of India versus Dharmender Textile Processor, which was decided in the background of penalty provisions in the Income Tax Act. However, the said decision of the Supreme Court does not hold that 100% damages must be invariably imposed. The decision is also not authority for the proposition that the circumstances that led to the default cannot be considered while deciding the quantum of damages to be imposed. In the facts of the present case, the tribunal has not set aside the damages under section 14B of the EPF Act. It has only reduced the quantum of penalty to 50%. This, in my view, is permissible
even when the requirement of mensurea and or actual resource is no longer a necessary ingredient for the levy of damages under section 14B of the EPF Act. It is to be noted that the provisions of section 14B of the Act do not prescribe that a penalty at 100% is to be mandatorily imposed.
So,
now, here in our case, my lord, the plea was taken that the after 33 years of the deposit, the proceeding was initiated. That is, that was not considered. Page 72 में है, इसमें one of the page is missing.
what is the total amount on which damage has been calculated?
It is about 5 lakhs, and out of that 5 lakhs, we have already deposited 75% of that amount before the traveller.
That's it. That is the mandatory deposit.
That was the mandatory provision. Now,
so total amount was 5 lakhs was assessed.
It was not. The assessment was not done. Therefore, we had approached the traveller. There was no assessment at all. Kindly see the order. Order dated page 72.
How?
Sorry, page 29. Page 29. Madam, ये देखा जाए last paragraph. The contentions raised by the establishment has been examined in detail, and it has been found that A1, there were some mistake in the statement sent by this office, means EPF. They admit that there was mistake. The statement submitted by the establishment has been taken on record, and necessary correction wherein incorporated. The establishment is a chronic defaulter. He says the delay in remittance of dues causes enormous loss to the fund. The damage levied against the establishment are in the form of reparation to the loss of the fund as well as penalty to the defaulter. This has been upheld by the resolution. The act of limitation does not apply in this case as pronounced by the High Court and so and so. So and what was our plea? That is para 3 में दिया हुआ मुझे para 2 for no opportunity was given for damages. 2 for damages under 14B. It had been stated that
this assessment is not arising out of. This assessment is not arising out of any assessment under 7A. There was no 7A proceeding. Normally there is a 7A
proceeding that
and then in after 7A proceeding there is a proceeding for assessment of damages. Do you want to say that there was no proceeding under section 7A
at all, because the amount was already deposited prior to this period? Now kindly see the period is 1071 to 199, 1071 to 199, and this notice has been issued in 2003, 36 2003, second line of the order. 36 2003 is the notice, and thereafter we appeared, submitted, but not considered anything. We have specifically submitted that we have no records because the company was closed और इतना पुराना हमारे पास record ही नहीं जिस verify कर सके, and the amount was already, there was no proceeding at all. There is no allegation of any proceeding which was pending before any authority, and there is no determination even.
What is account 1?
Account 1.
Account 1, account 2, account 10. EPF Act. What is account 1?
Some pages of my brief is missing actually. I got Xerox copy from the other side. As this is the calculation how they have calculated perhaps. This was the amount 5,22,000. This was the assessment. How they have assessed, nothing has been mentioned. And our contention that has not been taken care of. Or And rule 32A देखा जाए हुजूर 32A of Employees Provident Fund Scheme 1952, that gives the procedure how that amount has to be calculated. 32A and 32B.
You see,
No.
32B provides that
May reduce.
the power to reduction is with the central board,
Yes.
right? So if you want any reduction, then you should have approached the central board. But how the authority has got a power to reduce?
Notice has been issued by the authority, not by the board.
No. You see, who moved the appellate tribunal?
I moved.
You moved the appellate tribunal.
Against the order of.
So therefore, against the order of damages, in order to seek any kind of waiver or reduction, the only authority who has got the power is the central board.
No, tribunal has also got the similar power.
From where do you say this?
I will
Show me some provision that the tribunal also has the power to do so. Because 32 is giving specific power to the central board. Isn't it?
Central board may reduce or waive damages levied under 14B of the Act in relation to issues specified in the second
right.
proviso to section
Yes.
14B,
Yes.
subject to the following terms and conditions.
Yes.
In case of change in management, including transfer of undertaking so and so, in case where the board for industrial and financial in other cases, depending on various reduction damage up to 50% may be allowed. So board has got the power, but I don't know whether after exercising that power notice has been issued or before that. तो record मंगाना पड़ेगा.
Record का कोई काम नहीं है.
There are judgments which says that the board has power to reduce the penalty and the tribunal has also got the similar power.
Where is the rate prescribed?
Rate?
Yes. 32A.
32A.
Right? पढ़िए तो जरा.
Where an employer makes default in the payment of any contribution to the fund or in the transfer of so and so, or under 17 of the Act, the Central Provident Fund Commissioner or such official as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty damages at the rates given in the table. These are the conditions which has been given in any condition transferred under subsection 2 of section 15 or subsection 5 of section 17 of the Act, or in the payment of any charges payable under any other provisions of the Act, or under the scheme, or under any of the conditions specified under section 17 of the Act, the Central Provident Fund Commissioner has got the power. Now, the default, if the default is less than of 2 months, only 5% damages, the rate of damages, a percentage is given, or 6 months is the maximum, जिसमें 25%. The damages shall be calculated to the nearest rupees 50 paisa of the Now the power is vested with the Central Provident Fund Commissioner or such officer as may be authorized. So officer has exercised its power and issued notice in 2003. Thereafter we appeared and he has passed an order in 2004. Against that appeal was preferred and the appellate tribunal has exercised its power.
You see, it has got a maximum of not exceeding the amount of arrears as may be specified in the scheme. Suppose the arrear is 10 rupees, then the damages cannot be recovered more than 10 rupees.
That nothing has been said in the order. What was the area which was for which the delay was there in depositing that amount, and the amount, the percentage is also given. In what manner they have to calculate, and that too after. Your Lordship, I would like to show para 29 of this judgment. This is 1998. This will clarify the position which lays down the law on this subject, on this issue itself. This is Hindustan Times Limited, para 29. May I read, madam? From the aforesaid decision, following principles can be summarized. The authority under section 14b has to apply his mind to the facts of the case and the reply to the show cause notice and pass a regional order after following principles of natural justice and giving a reasonable opportunity of being heard. The Regional Provident Fund Commissioner usually takes into consideration the number of defaults, the period of delay, the frequency of default, and the amounts involved. Default on the part of the employer based on plea of power cut, financial problem relating to other indebtedness, or the delay in realization of the amount paid by the checks or draft cannot be justifiable ground for the employer to escape liability. There is no period of limitation prescribed by the legislature for initiating action for recovery of damages under section 14b. The fact that the proceedings are initiated or demand for damages is made after several years cannot by itself be a ground for drawing an inference of waiver or that the employer was lulled into belief that no proceedings under section 14b could be taken up. Mere delay in initiating action under section 14b cannot amount to prejudice in as much as the delay on the part of the department would have only allowed the employer to use the monies for his own purpose or for his business, especially when there is no additional provision for charging interest. However, the employer can claim prejudice if there is proof that between the period of default and the date of initiation of action under section 14b, he has changed his position to his detriment to such an extent that if the recovery is made after a large number of years, the prejudice to him is of an irretrievable nature. He might also claim prejudice upon proof of loss of all the relevant records and or non-availability of the personnel who were several years back in charge of these payments, and provided he further establishes that there is no other way he can reconstruct the record or produce evidence, or there are other similar grounds which could lead to irretrievable prejudice. Further, in such cases of irretrievable prejudice, the defaulter must take the necessary pleas in defense in the reply to the show cause notice and must satisfy the authority concerned with acceptable material. If those pleas are rejected, he cannot raise them in the High Court unless there is a clear pleading in the writ petition to that effect. So a specific plea was made before the authority, before the tribunal, and thereafter it was considered by the tribunal. If I may permitted to read the order of the tribunal, then it will be more clear.
That's right. So quantum is a flexible amount.
Yes.
It may not be automatic to the extent of 100%.
Yes.
This is the view of Honorable Kerala High Court.
Kerala High Court.
Yes.
And this Madras High Court one judgment was given by learned friend that I have given. So Ojapati jo dikhaya the that says about the power of the central authority as well as the authority both have power to reduce the quantum of the amount. Determination.
No, it says that it acts as an appellate
Appellate.
authority so far as board is concerned.
Both.
No. So far as board
Appellate
is
authority
concerned.
for the orders passed by the authority as well as the central authority. Orders passed by the central authority.
So, in a case where there is a sick unit, then under such circumstances, the the board is the competent authority to waive. So directly the tribunal cannot do it. It was there in the previous case because they were claiming that they were secured and their application was pending before the board.
That is a different provision altogether.
सुन लिया? तो वकालतनामा कब फाइल कर रहे हैं?
Within 1 or 2 days.
आपका भी मंडे को रखते हैं, वो एक मैटर मंडे को रखते
Monday I am out of station. For I am praying.
Friday को रख लेंगे.
Monday and Tuesday I
हैं.
am
तो फ्राइडे
not
को
able
तो
to
फ्राइडे
reach
को
me.
है. He
This
is
Friday.
available on Friday.
This Friday. This Friday.
Learned counsel for the parties are present. Counsel for the petitioner has submitted that he has received instruction to appear in this case and he will be filing wakalatnama by day after tomorrow. Pose this case for final disposal on Monday, on Friday.
Friday.
5th.
इसको डिसाइड करते हैं, ठीक है? It is required to be decided. Delay, we will see what is the ground for whether there is any explanation for the delay in which they have done, because there is a delay of about 35 years.
I have calculated it is 33 years.
Delay by itself will not be a ground to reduce.
That may not be. That may not be a ground that the Supreme Court has itself
Yes.
said. But the thing which is irretrievable prejudice if it is caused due to the circumstances, that is change in situation, that has to be taken care of by the authorities concerned. While
So what is the change in situation in your circumstances?
my change in situation
The unit
is
was
that
closed.
yes, it was closed. The file of that period was not available. The person who
The
was
file
working-
was not required because there is no assessment under 7.
no assessment.
So therefore, whatever you have deposited it yourself, isn't it? आपने खुद
there was no
जमा किया
assessment.
है.
Yes,
There was
yes,
no
yes.
assessment, so
There
there
was
is
no
no question of any dispute, and you
Yes.
are not prejudiced by non-availability of any records because you yourself had deposited it. 1991 का claim जो है वो amount आपने समझ लीजिए 95 में deposit कर दिया. तो उनका ये है कि 91 से 95 तक का जो calculation होगा that you'll have to get. This is how it is calculated in the case.
Then 7A का proceeding that should have
Not
been
required because you have already assessed it yourself and deposited. It is only
that
with
is
regard
not-
to delay in deposit.
because the
Because
notice
the order under section 14B is not referring to any assessment under section 7. There is no assessment under section 7.
even I am not aware about the situation कि उसमें कैसे जमा हुआ था.
वही ऐसे दिख ही रहा है, वही इसी तरह से ही जमा हुआ था.
Because
सुओ मोटो में
the
जमा
notice-
करते हैं लोग.
Even the notice does not disclose the
No.
basis of calculation or basis of issuing notice.
That is there. 14B का है statement.
14B का notice है, बल्कि 14B का penalty आप propose कर रहे हैं. What was the basis for that? That has not been disclosed in the notice. Anyway, I will get it prepared.
This is something which is required to be decided for all times to come, because EPF authorities are mechanically applying section 14B and
So
imposing the
after
at
such a
any
long
point of
period,
time. At any point of time.
any point of time.
ठीक.
Item 9, WPL 3226 of 2013.
Lordship, may please just have a look to annexure 12, page 107.
Yes.
This is the award passed by the Central Government Industrial Tribunal, come Labour Court, Bhubaneswar. Present such and such between the management of such and such versus their workmen. The relevant portion, if your Lordship please just have a look to page 109. Issue number 2, paragraph 7. During course of argument, it has been considered by both the parties that the representation of the disputants were sent to the government, who has agreed to extend the benefits of pension scheme to 25 disputants who are concerned in this reference. In that case, there is no scope for this tribunal to express any finding. On the other words, when the appropriate government has accepted that representation, it would suggest that the claim of the disputants is fully justified. Issue number 3. During course of argument, it has been submitted on behalf of the second party that time limit may be fixed by this tribunal to make payment to the disputants, and no objection has been raised on behalf of the first party management. It has been stated that the time limit should not be very short, considering the nature and gravity of the case. When the government has accepted the representation of the disputants to provide pension benefits to them, it should be worked within 6 months from the date of receipt of the Gazette notification, and this was allowed. On the last date, your Lordship, when the matter was heard, my learned friend of the central government, he was asked that this relates to the pension amount of only 25%, and they had before the Labour Court already agreed that the payment will be made and a time should be fixed, but that has not also been done, your Lordship.
No, this award has been passed at Bhubaneswar. You want execution of this award?
Not execution, your Lordship,
Because one of your prayer is that this should be implemented. That amounts to execution of this award only. If there is an award, you execute it as per the provisions of Industrial Disputes Act. An award which has been passed by Labour Court within the jurisdiction of Odisha High Court, under this writ jurisdiction, ignoring the provisions of Industrial Disputes Act, how an order can be passed for execution of this award?
Your Lordship, because of the agreement by and between both the parties before the Labour Court.
Whatever may be, we are not on that. One of the prayers is that it should be implemented. And how do we pass such an order?
No, then there is another prayer also.
So you forget about at least that prayer. No, we will see it prayer wise, one after another. Right? One of the prayer as I see is prayer number C. Right? Another prayer is commanding the respondent to treat the petitioners at par. So this is also something which would certainly fall within the realm of Industrial Disputes Act.
Your Lordship, may please just have a look to prayer number A.
Yes, prayer number A. Yes. So basically it comes down to prayer number A only.
Only for that, your Lordship, this matter was, although filed in the year 2013 and it has travelled even up till now, only because of this. And on the last date, they were said that
there is an order also that you will satisfy this court on the point of maintainability of this.
That is at paragraph 40. Let them answer to that.
No, we'll see that.
Yes,
first you tell us. So what remains is prayer number A.
A.
You argue on prayer number A. What is it?
The main prayer, your Lordship, is that when there was an agreement by between both the parties and only 25 persons were
to be given the pension amount, that is the enhanced pension amount according to the civil that is given, your lordship. He was directed to ask the central government why they are not making that payment. That will serve the purpose. And 21 long years have already passed.
We are not going to enter that. We do not have the jurisdiction to enforce an award.
Then your lordship, may I please hear this case?
Yes, I am hearing it. You argue.
As far as maintainability is concerned, please just have a look to paragraph 40. In details, everything has
Kindly
been...
place para 40. Para 40.
That initially the petitioners were appointed under the NCDC. NCDC means, your lordship, National Coal Development Corporation. Thereafter, the petitioners worked for the Central Coalfields Limited for some time, and subsequently they were transferred to Southeastern Coalfields Limited. And lastly, the services were transferred to Mahanandi Coalfields Limited. However, the apex body of all the subsidiaries is the Coal India Limited, and the petitioner's services lied under its jurisdiction. This Honorable Court has jurisdiction to entertain and hear this application. Moreover, it is the central government who has to ultimately take decision, and thus this Honorable Court has jurisdiction to decide the matter. Now, your lordship, it is the central government which has to take a decision as to what, after the award, your lordship, when there is a agreement by and between both the sides and they have accepted that the money will be given to these 25%, there is no scope of further dispute with regards to that matter, and the authority concerned should take a decision that the payment should be made to these 25%.
So, whom are you representing? The same 25 persons who were...
Yes, your lordship.
But it is not clear from your petition.
No, the union has represented the same 25%. Not one more, not one less.
See, this union, from where do you say that this union is representing the
Paragraph
same...
5, your lordship, may please see paragraph 5.
Yes, where do you say that they are the same 25 persons who had approached the industrial tribunal in whose favor the order was passed? Where is it mentioned?
Paragraph 12. That the present employees being represented through the petitioner number 1 union were monthly rated employees appointed between 23 to 56 and
This
11.
is for everybody. I want to see that you are representing only those 25 persons which you have just said that who were party in that award. So I want to see it from you, from this record, that you are representing only those 25 persons.
The names of the persons we have not given, but
Even 25 persons you have not mentioned. That you are representing, your representation is limited only to 25 persons as you submitted. So I want to see that. And if there is already an award in favor of the persons whom you are representing, then where is the question of challenging the Coal Mines Pension Scheme 1998? And why should you challenge it at all? because you should be happy with that award.
Ladies, two more things that has to be seen. The address of the union is also of Angul, Delubara Colliery, which is not under the jurisdiction of Jharkhand. Now, my lord, this is the admitted position. If para 2 of the award is to be seen, the case of second party may be stated in brief. 25 persons as per the list concerned in this reference, they were working under first party management. So it is an admitted position that they were working with management chairman cum managing director Mahanadi Coalfields Limited, and that award is from Odisha.
Let him finish and then I'll do it. I'm waiting him to complete.
That is the case, Your Lordship. I have stated at paragraph 40 as to how the jurisdiction came, and because firstly they were in the National Coal Development Corporation, which after nationalization, Your Lordship, became CCL. Thereafter they were sent to Southeastern Coalfields, subsequently to Mahanandi, and they come under the Coal India Limited. And we have challenged, as I have already stated earlier, Your Lordship, at paragraph A, for causing setting aside para 20, the Coal Mines Pension Scheme 98, as being ultra virus, Articles 14, 16, 19, 21, 39, and 300A of the Constitution.
Where is the scheme?
As it excludes 10 years of service of
Where
the.
is the scheme? Which you are
Annexure
challenging?
1 is the, Your Lordship, Annexure 1 is the wage board recommendations in respect of the monthly paid staff.
This is recommendation. Where is the scheme that you are challenging?
This scheme, Your Lordship, we have got that, but it is not there. Page 66.
You're challenging the clause of pensionable service.
Yes, Your Lordship.
Read it.
2O.
Read it. Yes.
Paragraph 9, Your Lordship.
First you read the provision that you are challenging, and then we will see para 9.
That is at page 66.
Yes.
2O.
Yes, read it.
Pensionable service means the 2/3 of the period of actual service rendered by an employee from the date of opting for the Coal Mines Family Pension Scheme 1971 and up to the 31st day of March 1989, except the period for which no contribution has been made to the Family Pension Fund, and the actual service rendered by an employee from the first day of April 89 or the date of service, whichever is entered to the date of retirement or the death in service. This we are challenging your lordship on the ground that the opting for the Coal Mines Family Pension Scheme 1971 and up to the 31st day of March 89, except the period for which no contribution has been made to the Family Pension Fund. This your lordship will find at paragraph 12 and thereafter. This period of 10 years that has not been taken into consideration for deciding the pension under 2A. That the present, that is at paragraph 12, that the present employees being represented through the petitioner number 1 union were monthly rated employees appointed between 23 to 56 and 11,170 of Coal India Limited, including its subsidiaries like the then National Coal Development Corporation Limited, now known as the Central Coalfields Limited, that there existed the coal mines, and everything has been given thereafter, how this came and what will happen to the 10 years of service, that is at paragraph 23 and 24, which they have not taken into consideration.
You were working since when?
56, your lordship, we have
Since
stated.
56, right. Now, you had an option to exercise whether you want to continue with this or you want to continue with the old scheme.
Yes, your lordship.
So it's your option. If you want, it's okay. If you don't want, it's okay. That is at page number 67. All the persons have to make an option.
Your lordship will please see paragraph 22. Paragraph 22.
Yes.
That on 24/1998, again a circular wide number such and such was issued to the project officers of various collieries under the Mahanandi Coalfields Limited, including Dulebera Colliery, informing about a gazette notification number such and such, dated 23/98, issued by the Joint Secretary, Ministry of Coal, Government of India, along with the circular issued by the Coal Mines Provident Fund Commissioner Dhanbad, while his letter number such and such dated 6/4/98 regarding the implementation of the Coal Mines Pension Scheme 1998. The said Coal Mines Pension Scheme 1998 was formulated in accordance with the powers conferred under Section 3E of the Coal Mines Provident Fund and Miscellaneous Provisions Act 48 and has been made applicable on the employees of the coal mines covered under the Coal Mines Provident Fund scheme, subject to certain conditions. That on 6/5/1990.
See, you just can't go on reading like this. You can just straight away come to the point that it is arbitrary because of this reason.
10 years of
just
service.
formulate your point.
10 years of service of these petitioners who
These
are
petitioners means what?
25 years.
Only 25.
Yes. Who are
25 persons who were party in that award.
in that award.
You are only representing them.
Them through this union.
So once that award has been passed, you are also seeking a direction that the award should be implemented.
Yes.
Then why this challenge? And how does it affect you? How does this provision effective, you are on the one hand seeking implementation of that award, and on the other hand you are challenging a provision. I'm not able to understand. How are you aggrieved?
No, Your Lordship had pointed out that how will the jurisdiction come?
No, we will come to the. We are hearing you in as a whole completely. You tell us how, on the one hand, you say that the award should be implemented, and on the other hand, you also challenge the scheme itself. So, how are you aggrieved by the scheme? What is the cause of action to challenge the scheme?
The scheme because of Your Lordships that if the award which has been passed mutually on a mutual agreement, if that is not being implemented, Your Lordship, then I will have to challenge that part which I have prayed at.
If it is not being implemented, you go for execution. You have a remedy under law. If it is not being implemented, that is not a reason to challenge any provision. You go for its implementation. That was by mutual agreement. So that is an award, executable award. Is it not an executable award?
It is.
Then you go and execute that award. The WPL number 3226 of 2013 heard the learned counsel for the parties. This writ petition has been filed for the following relief. Upon repeated query made by this court, the learned counsel for the petitioner has submitted that the petitioner union is representing 25 workmen who were party before the Central Government Industrial Tribunal Labour Code Bhubaneswar in ID case number 73 of 2002, in which an award dated 25/20/2003 has been passed. He submits that with the mutual agreement, the award was passed, but the respondents are not implementing the same, and consequently a prayer has been made before this court to implement the said award. The learned counsel further submitted that since the award was not being implemented, a prayer has also been made challenging the para 2 within bracket O of Coal Mines Pension Scheme 1998, and by referring to the jurisdiction of this court, the learned counsel has referred to para 40 of the writ petition. The learned counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that there is no cause of action to challenge para 2O of Coal Mines Pension Scheme 1998. Once an award has been passed in favor of 25 workmen, the same is an executable award, and the execution would also lie before the competent court within the district of Bhubaneswar. No cause of action arises before this court. She submits that that's it.
मतलब ये जो pension scheme कह रहे हैं, that comes under central government as well as CMPFO, that is a separate entity. It is not governed by CIL and that is not a subsidiary to CIL.
Okay. The learned
CMPFO
counsel
has not been made party.
CMPFO.
Central Mines Provident.
The learned counsel has also submitted that the pension scheme is formulated and governed by Coal Mines Provident Fund organization, and it is a scheme framed by the state authority,
central government,
by the central government, and implemented by the state authority.
Yes.
But the state authority is not even a party before this proceedings.
No, Your Lordship. Respondent 2 is a party. Ministry of Coal, the Secretary Ministry of Coal, he is the...
We'll take care of that. She submits that no cause of action has arisen before this court merely because all the coal companies fall under Coal India Limited. That does not mean that the present writ petition would be maintainable.
I'm appearing only for CCL and CIL, not for all the respondents.
Okay. CCL, she represents CCL and
CIL.
CIL. At this, the learned counsel for the petitioner has submitted that the Ministry of Coal through Secretary Shastri Bhava, through its Secretary, the Government of India has been made party, and therefore the Coal Mines Provident Fund Organization is also represented. After hearing the learned counsel for the parties, and this court finds that the petitioner was put repeated question as to the persons whom he is representing, and in response he has made a categorical statement before this court that he is representing only those workmen who were party in the aforesaid case before the learned tribunal. The petitioner is aggrieved by non-implementation of the said award. This court finds that such prayer cannot be is not maintainable before this court on account of the reason that the award passed under Industrial Disputes Act is to be executed in terms of the provisions of Industrial Disputes Act 1947. This court further finds that no cause of action has been shown by the petitioner with respect to the aforesaid 25 persons whom the petitioner is representing for challenging the paragraph 2 within bracket O of Coal Mines Pension Scheme 1998. This court also finds that under the provisions of Coal Mines Pension Scheme itself, the employees have to exercise their option in terms of clause 4 thereof. In view of the aforesaid facts and circumstances, this court finds no merit in this writ petition, and accordingly it is dismissed. However, this order of dismissal will not stand in the way of 25 persons in whose favor the award has been passed by the court at Bhubaneswar, if there is no other legal impediment for implementation of the award.
Item 10, Criminal Revision 1342 of 2023.
But discharge application will be rejected by the court. The complaint case was filed on 13/12/2016.
What is the date of marriage?
Date of
Marriage.
date of marriage is 10/6/2009.
Date of
The
death.
Date of death is 18/4/2016.
10/6/2010 is the date of marriage. 2009.
2009.
18/4/2000.
18/4/2015, I suppose. 16 on this.
2000.
We just check.
Within 7 years.
That is within 7, 2-3 months within 7. I'm not challenging with that. Now the disease is Mamta Devi. This is Mamta Devi. Now it is a typical case. I would need to read the complaint The complaint.
We are on the stage of discharge.
Yes.
So kindly let us know, is it your case, the discharge is being filed by all the persons?
Yes.
All the accused persons?
Yes.
Okay. Including the husband,
Yes.
every family member?
Every family.
Okay, right. So the point is that what is the ground for your discharge?
Yes.
You confine yourself to the scope of discharge.
Yes. So
Is it your
this-
case that there is no material against you?
Yes. Yes. Rightly said.
So no material against the
No
petitioners.
material against us. First of all, we have to see that if at all any case is made out from the allegations leveled in the complaint.
It was
Now
sent for investigation.
The girl dies because of cancer. It's an admitted case.
From where do I get that she died because of cancer?
Yes, yes, yes. I'm highly obliged to my lords. Let us go to the complaint. That's why I was just reading the complaint. The complaint is all the more necessary because I'll have to give in details as to what are the relationships. There are two sets of accused. One, the near relations. The other is the distant relations.
No, that is a separate case.
Okay.
When once you say that no case is made out,
No
so
case is
near
made
or dear or far, that does not make any difference. If no case is made out, it means no case is made
No case.
out. So you confine yourself to no cases made out.
Let us read the complaint. Let us read the complaint. First,
Where is that she died out of cancer?
yes, my lords. If your lordship comes to
Which paragraph?
para 11,
Yes.
now here from regarding the medical condition of the deceased, the complainant hospitalized his daughter on 12/12/2015 at Savitri Surgical Maternity Center, Dhanbad, on 13/12/2015. Sangeeta Karnhens, Dhanbad, and subsequently on PMCH Saraigla, Dhanbad, and on 12th so and so, she gave birth to a dead baby in the serious condition. Anyhow, the daughter of the complainant could be saved. She was discharged from so and so 11/12/2015, and the complainant brought her daughter Mamta Devi to his residence on Karmi Nagar, Dhanbad. But the condition of the daughter of the complainant did not remain well, hence she was admitted on 2012-2000 at Savitri Diagnostic Center, Dhanbad, from where the daughter of the complainant was referred due to critical condition of daughter of the complainant Raj Hospital, Ranchi, on 21/12/2015, Ranchi Hospital, Ranchi, 4/1/2016 to Dhanbad Hospital, and 8/1/2016 again to Ranchi Hospital, Ranchi, and then to DSP Hospital, Durgapur, and 1/3/2016 to Tata Memorial Center, Mumbai, and on 7/3/2016 also to Chittaranjan National Cancer Institute, Kolkata, and 26/3/2016 she was also referred to Tata Medical Center, Kolkata, 28/3/2016 to CMC Hospital, Vellore, on 4/4/16 lastly hospitalized at Tata Medical Center, Kolkata, on 8/4/16, and during the treatment the daughter of the complainant, namely Mamta Devi, died on 18/4/16 at Tata Medical Center, Kolkata.
So,
now what is the complaint?
No. Where is that postmortem report?
They did not go for it because this was a natural death. When the complaint is being lodged, when she died in 18/4/2016. The complaint is being lodged.
Merely because she was taken to cancer hospital, merely because she was, so we will assume that the cause of death was cancer.
This is the case. This is the
She
case.
suffered some problem during pregnancy, and then there was a continued treatment,
Yes.
right? And then the allegation is also that
That this happened because of the petitioners. Let us see where is that allegation. Let us see. And then we'll read the sections which have been leveled against us. And then in conjunction the allegation has
you
to
just see para number 9.
Yes.
The allegation is that you created a situation of this nature. Para 9.
The third pregnancy of the daughter conceived in the first week in April 2015. Despite this, all the accused were subjected to cruelty. At this stage, the accused persons did not provide a proper food, medicines, due to which the position of the complainant daughter became serious, and due to said cruelty caused accused person daughter suffered from less blood in her body and her position became very critical. That the accused persons showed their inability for a proper treatment. That is the allegation. Showed their inability for proper treatment of the daughter of the complainant and refused to provide medicines to her. The complainant took away his daughter from in-laws' house to the house of the complainant at Karmik Nagar, Dhanbad for proper treatment on 11/12/2015. Your Lordship has got it, matters. And then let us come to para 13. What is their grievance? That the complainant bore the entire medical expenses during the treatment of his daughter Mamta Devi, and accordingly the complainant spent 10 lakh rupees, including the treatment cost of rupees 7,70,000. But the accused persons did not spend and bear any amount on treatment of the daughter of the complainant. That the complainant thereafter brought the dead body of his daughter Mamta Devi, and Dah Sanskar of his daughter was performed. That on 28/4/2016 there was Das Karam in the in-laws house of the deceased daughter. The complainant and his family members attended the Dah Karam of his daughter Mamta Devi, where the accused persons were talking about themselves that now that the accused number 1 will solemnize his second marriage and they have been succeeded in the finish her life by conspiring such thing. That on this the complainant and his family members told to the accused persons that there will be the children of the deceased daughter of the complainant. Then the accused persons became furious on the complainant of his family members, saying that जो करना है कर, तुम्हारी बेटी तो मर गई, तेरी so and so, so and so, so and so. Pretended the complainant, his family members, complainant's strong belief that the accused persons conspired the death of daughter in the name of non-fulfillment demand of dowry. That on accused persons ousted the complainant and his family members from their house and quarreled with the complainant and his family members on the day of Dhaka. That seeing the future of the children of late Mamta Devi, the complainant's family members returned back at Dhanbad. At the time, the children were with the complainant. Now, this is the main allegation, what happened on 11/6/2016. That on 11/6/2016 at
There
9...
is a clear allegation that she had called up and then she said that they are not going to take any treatment for her, and then she called her parents and told them that they are not going to give any medical treatment to her, and ultimately it was the parents who had taken steps to treat her. This has come in during investigation also, right?
Yes. That is,
So,
this amounts to an offence.
so therefore, at the stage of discharge, how do we decide this? There is a
Going by the sections.
we go by the
304B.
section. Let us see.
Let us see
Let us
304B.
see 300.
Yes, 304B.
Let's see. Like,
Whether any of the ingredients of 304B is met.
that's it. Not providing food to the wife, will it come within the meaning of cruelty or not?
Cruelty for what?
We do not.
It can be a case under section 4. Again, that will be a separate offence for that. Let us read 3 and 4B and then we'll decide.
Later on, please don't withdraw.
I will not withdraw. I will not withdraw.
बाद में withdraw
नहीं.
Minus, just one thing, if I may just submit minus. Now the stage has moved on, my lord. Charge has also been framed. It is at the stage of evidence, my lord. Now.
Evidence has commenced.
My lord, it is about to commence on 12/8/24. That is the first date.
Charge has been framed.
Yes.
Is that, then I will have to challenge that charge order framing charge.
You argue.
Maru Salar.
Yes. Read 498. This 304.
Yes, was 304B. Yes. 304B dowry death. When the death of a woman is caused by any burns or bodily injury or occurs otherwise than under the normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for any in connection with the demand of dowry, such death shall be called dowry death, and such husband or the relative shall be deemed to have been caused.
Which amongst these ingredients is not satisfied?
None of them is. Number
Alright.
one, this is a normal
So
death.
none of the, this is a normal death.
This is a normal death.
Okay. Then
Soon before her death, there is
Soon
no
before
such cruelty for the purpose of demand of dowry.
no cruelty. Then
For the purpose of demand of dowry. This is one of them. Now my case is mirrors. Now the reason has been assigned as to why this case has been lodged. Let us come to the para 19 wherein what they have to say.
you
So there
see,
are two
just
reasons.
a moment.
There are two reasons.
Soon before her death,
Yes.
it is not only relatable to dowry, it is
Yes.
other aspects also.
Yes, let us see.
Read
What are the other aspects?
Yes.
What are the other aspects? And whether it is
It is shown that soon before her death, she
Death.
was subjected to cruelty or
Yes.
harassment
by her
take second, by her husband or any relative of her husband for or in connection with any demand for dowry, such death will be called dowry death.
So there has to be a demand. There has to be a demand. And in consequence of that demand, that cruelty is done and the death occurs because of that particular cruelty. That's it. Now, whether this is a normal death or that your lordship has to give a finding. Whether this is a normal death, she died in a hospital, she was undergoing treatment and then she died. She was in several cancer hospitals, she undertook treatment. Now there are two reasons why this case has been lodged. Number one, there is non-payment of the, but it's non-sharing of, in fact I will say non-sharing of the money which was incurred during the treatment. And the second is at para 20.
Yes.
That they took away the children of the deceased. The children is with us. The children is with us. They never filed an application for custody of the children.
When father is alive, how where is the question of custody?
No, I'm saying what is the grievance? What has the grievance, actual grievance mentioned in the complaint? Now, when the death occurred, immediately after the death, there was no case. Everyone participated in the ashram as per their case only. Then this occurrence takes place on 11/6/2016. Then also they do not lodge a case. Then finally in the month of December, they lodge this particular case.
Occurrence is on 11/6/2000.
16, yes. This is what is there from the complaint also and from the allegations also. Your Lordship, come to page 19, the date and time and place of occurrence.
No, we have to see it from the averment.
From the averment itself. From the averment itself.
So, कौन सा para number? Para number?
But first was para Marut's 19.
Para 19. Yes.
Then thereafterwards, the occurrence as to what happened thereafter.
You read para 19 also.
No, so I'll read para 19 and thereafter the allegations. But that on 11/6/2016, 9 p.m. the night, the accused persons 1, 2, 4, 6, 7, 8 and 9 with deadly weapons in connivance with each other came to the residence of the complainant at Karmik Nagar and entered into the house of the complainant forcibly and started to assault the complainant and other family members and also abuse them. The accused persons also took away the children of the deceased Mamta Devi, namely Shubham Kumar and Mithi Kumari, and with them to Durgapur forcibly from the house of the complainant, and then such occurrence was being committed by the accused persons. The complainant raised halla, and then the witnesses came there, and seeing and the gathering of the accused persons fled away, giving threatening, हम लोग तो तुम लोग को और पुलिस को कुछ नहीं बिगाड़ सकता है, हम लोग कुछ नहीं कर सकता है, और जो करना है करेंगे, हमारा सामने आने की कोशिश नहीं करना, नहीं तो तुम लोगों को जान से हाथ धोना पड़ेगा. That on 27/11/2016 at 7:30 p.m. night, all the accused persons, number 1, 2, 4, 6, 7, 8 and 9, came to the residence of the complainant, Karminagar Dhanbad, with deadly weapons and forcibly entered into the house of the complainant, started to abuse and assault the complainant and his family members, and the accused 7, 8, and restrained the complainant party from saving their lives. The accused persons 1, 2, 4 locked the Almira house of the complainant, took around 2,25,100 rupees cash and ornaments, and rupees 1,65,000. All the accused persons damaged, broke the house, articles including TV, dressing table, other valuable articles, house of the complainant, causing damage of 40,000 with an intention to ruin the complainant. That on this the complainant raised halla, bachao, bachao. Persons including the witness started to gather there. Accused persons fled away, giving threatening so and so, so and so. The next day on 28th, the complainant went to the local police, reported the matter against the accused person. Couple commit to take legal action against him. Where is the allegation of 3 and 4B?
Anything else you want to say?
That is my case.
So there is no allegation. लिखिए. आपका submission लिखाते हैं फिर इनका.
हमारा कुछ जितना बोले उतना.
The learned counsel for the petitioner submits that it is an admitted position that the date of marriage is 10/6/2009 and the date of death of the lady is 18/4/2015, and the complaint was filed on
13/12/2016.
And by the impugned order, the prayer for discharge has been rejected. The charge sheet was filed for offence under section 341, 323, 342, 380, 458, 427, 304B, 504 and 120B of Indian Penal Code. The learned counsel has submitted that it is a case of normal death in view of the fact that the deceased had died in a hospital and was taken from one hospital to another, including hospitals treating cancer. However, admittedly, no post-mortem of the deceased was conducted. He has submitted that the basic ingredient for offence under section 304B is not attracted in view of the fact that the death was a normal death and there was no cruelty soon before the death with regard to the demand of dowry. By referring to the complaint petition, he submits that primarily the grievance of the complainant was that the petitioners did not share the money for the treatment of the deceased and they took away the children of the deceased. The learned counsel has submitted that merely because death had occurred within 7 years of marriage, the same does not automatically mean that the ingredients of section 304B are attracted. He submits that the impugned order refusing discharge is to be set aside as there is no material against the petitioners. आप बताइए.
Firstly, as the charge has already been framed, this stage of getting this, the stage of this criminal revision has passed, my lord. Now, my lord, senior will have to challenge the charge order also, my lord. And also from the charge, we'll have to see on what sections the charge has been framed, my lord.
And what about, and anything on merit?
My lord, on merit, there are allegations, my lord, of not providing food and not providing proper treatment. That is also the responsibility of the husband and the in-laws only, my lord.
The learned counsel appearing on behalf of the informant while opposing the prayer has informed this court that charge has already been framed and the evidence is to commence from 12/8/2014 and the stage having changed, the no relief be granted to the petitioner. She has also submitted that upon reading of the complaint petition and which was sent for investigation by police, there is enough material to show that the deceased was treated in such a manner that she ultimately fell ill. She was not granted food and medicines, and her condition was that she was not having enough blood in her body. And at that stage, she was taken to the hospital when the in-laws refused to undertake treatment for her, and she died in the hospital. She submits that there is also allegation regarding demand of dowry and ingredients of other sections in which charge sheet has been filed are also present in the case. She submits that it is not a case that there is no material against the petitioner. The arguments advanced by the petitioners are essentially arguments of defense. आपको क्या बोलना है?
There are sufficient material available on the record.
The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that there are sufficient material available in the records which has come during investigation. Statement of witnesses have been recorded and therefore no case for discharge was made out. The impugned order does not call for any interference. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the death had taken place within 7 years of marriage, and further no postmortem was conducted of the deceased, and accordingly the exact cause of death may not be available. This court further finds that as per the complaint, there are allegations regarding demand of dowry followed by torture, assault, and the complaint also indicates that the in-laws of the deceased were not providing, in-laws of the deceased did not provide her appropriate food and treatment, and the condition of the lady deteriorated, which led to a situation that she suffered from less blood in her body. It has also come during investigation. The statements of the witnesses have been recorded. During investigation, and it has come that the parents of the deceased took up the step for her treatment only when she called upon them, stating that her in-laws were not interested in her treatment and that if she is not treated, she would die. It has also been alleged there are other allegations also in the complaint and the materials collected during investigation. And ultimately, the charge sheet was filed not only under section 304B, but also other sections of IPC. This court finds that this court is of the view that the learned court, after considering the materials on record and the statement of the witnesses, was of the view that there was prima facie material available on record to frame charges, and accordingly the petition for discharge has been rejected. Considering the totality of facts and circumstances of this case, this court finds that the learned court has already considered the material, and at this stage the arguments advanced by the petitioner is essentially a matter of defense, and at this stage it cannot be said that no offense, that there is no material to proceed against the petitioner under the aforesaid sections for which the charge sheet has been submitted and as recorded by the learned court. Consequently, the present revision is hereby dismissed.
Item 11, Criminal Division 43 of 2024.
And further, the charge has already been framed, the stage has changed. Yes, petitioner?
By the Juvenile Justice Court was rejected. Thereafter, the appeal was preferred. Appeal has also been rejected. The case was under section 363, 366, A34. And the FIR is Mado at page number 19.
What is the age of the petitioner at the time of
17
years?
17,
17 years.
17.
His assessment as to whether he will be tried as an adult or as a child has been done. Section 15 का assessment हुआ है कि नहीं हुआ?
But so far this petitioner is concerned, madam, main allegation is against one D.K. Kumar.
आप हमारे सवाल का जवाब नहीं देंगे तो कैसे चलेगा? आपसे पूछ रहे असेसमेंट हुआ है कि नहीं हुआ? कहाँ पर लिखा है कि हुआ है?
Page 30.
Has not yet been done. Preliminary assessment under section 15 has not yet been done. अब तक तो हो गया होगा ना आपका असेसमेंट? बताइए. क्या पूछ रहे हैं आपसे?
That is, the case is found to be aged about 17 years, 6 months, 1 year.
So, आपका संगत भी सही नहीं है, आपका भाई भी आपके साथ जेल में. तो यही है. भाई है कि कौन?
फ्रेंड है.
फ्रेंड.
उसी के लिए किडनैप करने में ये लड़का जो है सो
चतरा से हटिया स्टेशन तक लड़की और वो एक्यूज विक्की कुमार को लेकर आया था मोटरसाइकिल से। यही अपराध है इसका।
The name of the petitioner is Madam Vishal Prasad, and Vicky Kumar was the main accused against whom there is a allegation.
लड़की का 164 का बयान हुआ है, उसमें क्या है?
उसमें हम पढ़ते थे जो है, उसमें है कि घटना 6-6-23 की है। मैं अपने घर पर थी तो मेरे घर का बगल का लड़का ओम कुमार पिकनिक मनाने चलने के लिए बोला तो मैं तैयार हो गई। तब सामान लेके विशाल, दिस इज द पिटिशनर, विक्की और मैं तीनों चौक में रुकने के लिए बोली तो बाइक तेजी से चलाने लगा। विक्की धमकी दिया, चुपचाप बैठी रहो नहीं तो तुम्हारी माँ बाप को उठवा लेंगे। मैं बीच में बैठा लिया। विक्की पीछे बैठा था या नहीं ले गया मुझे पता नहीं।
कहीं ले गया?
वहाँ से ट्रेन में बैठाकर दिल्ली की तरफ ले गया। जगह के बारे में मुझे याद पता नहीं। ट्रेन से उतरकर मुझे एक रूम में ले गया। पहले से विक्की के दोस्त थे, वहीं पर मुझे बंद कर चला गया और फोन भी ले लिया। वहीं पर मुझे 50 दिन रखा। विक्की मेरे साथ जबरदस्ती बलात्कार किया, लगभग रोज जबरदस्ती किया। फिर पुलिस वहाँ पर गई, हम लोग तो आ गए। फिर नीचे दी विशाल, दिस इज द पिटिशनर, विशाल हम लोग को ट्रेन में बैठाकर वापस आ गया।
That's right. लिखिए। Criminal Revision Number 43 of 2024. For the Learned Counsel for the parties. This revision is directed against judgment dated 6/12/2023, passed in Criminal Appeal Number 31 of 2023 by Learned Special Judge Child Act Cases cum Additional Sessions Judge 1 Chatra, whereby the said court has affirmed the order dated 29/23 passed by Learned Principal Magistrate Juvenile Justice Board Chatra and rejected the bail application of the petitioner in connection with Sadar PS case number 162 of 23 registered under section 363, 366A and 34 of Indian Penal Code. The Learned Counsel for the petitioner has submitted that the petitioner was more than 17 years on the date of occurrence and was declared juvenile. But and is in custody since?
Custody since 23/6/2023.
23/6/2023, and it is a case of false implication of the petitioner. He has further submitted that the learned courts have refused to grant bail to the petitioner, which calls for interference. The Learned Counsel, appearing on behalf of the opposite party state, has opposed the prayer and has submitted that the allegations against the petitioner are serious and it comes within the category of heinous offence. He has further submitted that the impugned order also reflects that preliminary assessment under section 15 of the Juvenile Justice Act has not yet been done by the Juvenile Justice Board. He has further submitted that the social investigation report of the petitioner has also been taken into consideration while refusing bail to the petitioner. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner is alleged to be involved in heinous offence. The statement of the victim under section 164 of CRPC was also recorded, and she had supported the prosecution case. This court also finds
confessed by the petitioner.
the confession in 164 statement का she it further appears that the social investigation report was also taken into consideration, wherein it was observed that
Page 30, Madam.
wherein it was observed that the economic condition of the parents are not good, and that the petitioner has been living with, क्या नाम इसका, विशाल कुमार कुशवाहा ना? Petitioner has been living with his aunt since childhood, and the expenses for his studies was also being borne by her. It has also been considering the fact also remains that the assessment of the petitioner under section 15 of Juvenile Justice Act has not yet been conducted as per the impugned order. Considering the totality of facts and circumstances of this case, and after going through the impugned orders, this court is of the considered view that the impugned orders are well-reasoned orders which do not call for any interference. Accordingly, this petition is hereby dismissed.
Item 12, Criminal Division 173 of 2024.
So this is juvenile bail matter, my lords. Yesterday, your lordship had made a query as to whether in this case.
You argue your case.
Yes, my
Don't
lord.
go
The
by
case,
my query.
yes, the case was initially registered under section 363, 364 of the Indian Penal Code, and my lord, and thereafter section 302 and 201 was added.
What is your age?
My lord, on the date of occurrence, my lord, I was 15 and a half years old, my lord.
From where do you say this?
My lord?
From where do you say this?
My lord, there's nothing on record to show this, but my lord, my year of birth is 2007, my lord.
So from where do you say this? You must have mentioned it in your petition somewhere.
Lord, in the party position only I have mentioned that at this stage, my lord, I'm 16 years.
Your age assessment must have been done.
That is not.
Where is it?
At page number 25, my lord.
Yes, पढ़ी. कहाँ है आपका age assessment?
Well, it is a submission by the petitioner of it is a submission of the council for the petitioner that the petitioner is minor and is below the age of 18 years, and hence the petitioner is juvenile. At page number 25.
Minor and below the age of 18 is not sufficient. We want to know whether you are below 16 or not.
At the date of occurrence, my lord, I was.
From where do you say this?
But there's no
What's on the next page? Next page.
Yes.
Second bottom two paragraphs के ऊपर में है. Further, the petitioner has been declared juvenile on.
What is his age?
Let apart. Nothing.
आपका नाम क्या है?
Lord, I'm Ankit Patel, ma'am.
No, Ankit Patel, right? अंकित पटेल का एज 16 years लिखा है at the time of arrest.
At the time of arrest, 2007, yes, 16 years, 15 and a half and plus.
We do not know 16 plus 1 day is also sufficient.
2007 is the year of birth, मतलब 16 years dot
From
2023.
where do I get this? You see, whether you come within 16 to 18 or not is a very important factor.
My lord, there is a judicial observation in the magistrate, in the order of the magistrate, that the juvenile, that he has been declared as to a juvenile on such and such date, my lord.
Juvenile means what? Less than 18 years. Then, whether this juvenile has to be tried as an adult is a very important fact. कुछ भी नहीं पता है, कोई डॉक्यूमेंट भी नहीं लगाए हैं कि हमको एज आपका पता चले. इसका ऑर्डर शीट आया है, क्या आया है इसमें?
Lord, I'll get the Aadhaar card of this person, Lord, my kindly pass
आधार
me.
कार्ड से आपका एज नहीं डिटरमाइन होगा. देखिए जरा, ट्रिब्यूनल रिविजन नंबर 173 of 2024. यहाँ पे केस डायरी तो कोई ऑर्डर से आया होगा ना?
Yes, my lord.
As per the impugned order, the petitioner was declared juvenile on 18/5/2023. But nothing has been placed on record by the petitioner to indicate as to what was the age of the petitioner on the date of occurrence. Office is directed to call for the order sheet, call for a report slash call for the records, a copy of the records from the learned court, which should include the assessment of age of the petitioner on 18/5/2023. And in case the petitioner has been found more than 16 or more than 16 years of age, then the report should also indicate as to whether the petitioner has been, as to whether required assessment of the petitioner has been made under section 15 of the Juvenile Justice Act. If that has been made, a copy of that report will also forward, communicate.
Lord, we kindly fix a date. All the measures have been granted.
We'll fix a date. Post on 1st of August.
My lord, I am very sorry. Monday को डिफिकल्टी नहीं होता, फ्राइडे को ही रखते हैं.
कौन सा केस का बात?
तो सीरियल नंबर 7 लॉर्ड से.
ऐसे नहीं हो सकता है. आप अदर साइड कौन?
जोगिंदर प्रसाद. हम बोल रहे हैं.
हमारे यहाँ से प्रोग्रेस चला जाता है, ऐसे नहीं होता. प्रोग्रेस होने के बाद हम उसको इससे बैक नहीं कर सकते.
तो मंडे को देखने का पर्सनल डिफिकल्टी है, इसलिए.
किसका पर्सनल
मेरा
डिफिकल्टी?
पर्सनल.
आपको तो सीनियर को बहस
सीनियर तो असिस्ट तो करना.
कभी आपका पर्सनल डिफिकल्टी, कभी सीनियर का पर्सनल
नहीं, वो तो
डिफिकल्टी, और हम लोग का पर्सनल डिफिकल्टी का क्या होगा? द प्रोग्रेस हैज ऑलरेडी बीन सेंट, है ना? हम लोग प्रोग्रेस में चेंज करेंगे तो काउंसिल्स को बहुत तरह का ग्रीवेंस होने लगता है.
उनको फोन करके बोल देंगे.
उनको फोन करने से नहीं. आप तैयार हुई, अपने सीनियर को बुलाइए, किसी और को नहीं तो लगाइए साथ में.